Good morning. Is it me or is it the topic that has you so excited this morning? I can feel the energy in the room. It's riveting. So hopefully you have had a great time at this conference, and hopefully I don't ruin that for you this morning with this keynote session on, I would say, in my 33 years of working with school districts in the area of educating students with disabilities, and particularly the legal compliance part of it, discipline has been the #1 hot topic in all of those 33 years. And it continues to be more so as we are nationally dealing with all of the concerns we have with the significant increase amongst our students of mental health issues, those concerns. For those of you who were not with me yesterday, just by way of introduction, I am from LA, Lower Alabama. I actually live in Mobile, Alabama, which is along the Panhandle. And many of our clients are in Florida. And of course, I'm worried about them terribly right now with Dorian headed that way and maybe even into the Gulf Coast. So we've got a couple of days ahead of us, including, unfortunately, the Labor Day holiday, to be concerned about that, but also concerning significantly in Florida. Obviously, this is a national issue, but concerning to a lot of my Florida clients is the fallout from the Parkland school shootings, which I think everybody's familiar with. It really got these discussions going seriously. Had they been more serious earlier, that would have been nice, but the Florida legislature in some respects has overreacted a little bit. And so what we're doing is dealing with the whole mandate under Florida law now for threat assessment teams to make decisions about students with disabilities. And I can tell you that if a student with significant mental health issues has not been identified as a student with a disability, either under IDEA or 504, they will be. I mean, that's kind of where we are with that. But the law down there pretty much directs school folks to remove students from school if a threat assessment team believes they need to be removed. And that has caused a lot of concern on my part with respect to how that aligns, if it does, with federal law. So I would say that these days, since all of this has happened, and this is certainly a national trend now, like our legislature in Alabama is looking at similar legislation, Georgia, it's just everywhere in terms of, the copycat legislation. But what I am concerned about is getting all of these phone calls. On a daily basis, I would say 5 to 7 calls I get with respect to a student with special needs, either under IDEA or 504, who is in front of the threat assessment team. And while some of the districts understand that IEP teams need to be involved if there's going to be a change of placement, many of the IEP team members are telling me, well, who are we to question the threat assessment team? If we think that the child with autism probably shouldn't be removed to community instruction, is what it's being called, can we say that? Or are we going to be thrown under the bus if this student actually does fulfill the threat that they made on social media or whatever? So it's really, really a tough time right now. And all of these rules of discipline clearly play into it. Even though I'm trying to convince everyone that we should stay out of the whole conversation about discipline, it still always comes in to this conversation. So that is the national concern as far as I'm, working in my profession, my law partners. I have an office in Mobile, Alabama. That's the Lower Alabama office, one in North Alabama in Birmingham. We have one in South Florida, in Naples, Florida, and we all 3 lawyers, we all focus specifically on representing school districts in the area of special education. And all 3 of us are sensing the same thing. This is a huge issue. So I'd like to say a few things before I get started and get into the content. That's my introduction in terms of what I've been doing the last 33 years. But specific to this presentation, I do want to remind everybody that we are not in Roman times, which means we don't kill the messenger, right? That's just me. I specifically remind school administrators of that, and I don't imagine that any building or local school administrators, or many are here. Are there any school administrators, principals? Oh, that's great, actually. I'm surprised by that. Thank you for being here. So I will say this, and I always say this to the rooms full of administrators when I'm doing a discipline type presentation. Usually it's a day and a half long sort of thing that I like to do, but I always start by saying, if you hear me say something this morning that makes you go, all right, you heard me wrong. Okay, so if there's anybody out there celebrating, yeah, I told them that's what it was, something's up, check in with me, write a question, put it in the panel box for this afternoon, because we will make sure that we clarify. Because unfortunately, there's not a whole lot of good news if indeed the ultimate goal is to get that child out of school. It's not easy to do that. In fact, it's almost impossible in many cases. I know that. I think the law needs a lot of revision. It needs to be revisited, but I don't know when that's going to happen. So as my dad used to say, it is what it is. The law says what it says. I'm not so sure it clearly states a lot of things. I've been grappling with that for 33 years. I mean, I know this morning I'll probably pause a couple of times and think about what I just said. And, is that right? Because there's a lot of room for interpretation in there where the law is not clear. Imagine that, Congress not being clear. But this area of the law, every time the IDEA is reauthorized, this is the area that always sees change. There are other things that Congress has never touched, even since the 70s, like least restrictive environment and all of those kinds of things. Discipline rules change every time. So when I talk through my rules of discipline, this morning I'm going to cover 16 of those with you. But there was a day when I had 8 of them. Then we got an amendment to the law and it went to 12 of them. And then we got another amendment in the law and it went to 16. So that's where we are. And it's interesting too, I always thought it was curious because Congress would always say every time they amended the disciplinary provisions, they would say, we're trying to make things easier for school administrators. Like, well, if you made it easier, why do I have to keep adding rules to my presentations? So I don't think they made it any easier. And every time Congress says something like that, the hair on the back of my neck goes straight up. Because I'm like, oh no, they're trying to make it easier, which means it's going to be worse. So they do always add and have been adding since basically the first version as it relates to discipline of students with disabilities. So my understanding is for the general sessions that you have a copy, an actual printed copy of my handout. You don't have copies of the slides. I didn't even think to send those because really all of the information on the slides is in the handout. That's kind of how I do things. The PowerPoint is just a kind of an extra visual tool. But if anybody should need the slides for any reason, just let me know and I'll be happy to send those to the IEP Resource Center folks, okay? So you can have access to that. All right, so what we're going to do is we're going to really hopefully build the foundation of understanding of the disciplinary rules that in my view are very, very complex and confusing. And that was the thing that I always have worked to do so hard. This was one of my very first presentations actually, with my knees knocking together so loudly I could hear them. Way back when I first started, within 2 years I was in front of a group of principals talking about discipline of students with disabilities. And frankly back then they thought I was making this up. And so I tried to come up with a easy to understand outline of the rules of discipline to form a foundational understanding and a framework. And so my hope is that for most of you, particularly those of you who are seasoned, special education directors or administrators, hopefully this is kind of just a review, an overall review of the framework of the law as it relates to discipline of students with disabilities. And then after I finish those, I'm going to talk more about some of the practical implications, so some of those really common questions that I get like how does bus suspension fit into this, and in-school suspension, or whatever the school tends to call whatever that is, those kind of practical implications of these rules. So I have a lot of information to cover, but I was mindful of the fact that my time was limited with you, and hopefully I can time this well and we can get through all of those rules and the practical implications. With a room this size, I think it's almost impossible really to effectively take questions. So if you have a question that's generated certainly from anything you've heard at this conference so far, but by this presentation specifically, I'll just reemphasize the fact that those cards are out there for you to write up your questions, and you get a whole panel's perspective. Yesterday I said to the group, yeah, you'll have a whole panel that will say it depends in answer to those questions instead of just one of us. But sometimes that does wind up being the answer, it depends. Because a lot of times in special ed, it does, right? So I always apologize for that very unclear answer, but I can tell you lots of times that is the answer when it relates to a question of discipline of a student with disability. All right, so let's get started then. And obviously, like I said, we've got 16 rules to cover, and I'll be moving through those quickly, which is a hard thing for this slow-talking Southern girl to do. So we will do as quickly as I possibly can go through. Now, in case you didn't attend anything yesterday, or in case you've forgotten yesterday, or repressing it for whatever reason, I just want to remind you that obviously the applicable laws for this presentation are federally based. And sometimes as I travel around the country, states might do little things that are different, might have a certain rule, like in Mississippi, for instance, they have a 5-day rule instead of a 10-day rule. And that comes from some old litigation they had, so there might be some nuances, but as I travel, most states generally adhere to the federal scheme. And the federal scheme is primarily dictated for our special education students under IDEA. But our IDEA covered kids are also covered, all of them, under Section 504. Right? It's anti-discrimination provisions. So 504 and its sister statute, the Americans with Disabilities Act, although I don't focus on ADA that much as it relates to discipline, 504 is kind of our go-to. IDA and 504 are two primary federal statutes. And as you well know, there are students that are not necessarily identified under IDEA, but may still have a disability and be covered under 504. And I refer to those students as 504 only students with disabilities. So we have our 504 plans out there sometimes, and even sometimes we have a student that doesn't need a 504 plan but has a disability. These rules apply to those kids as well. A little different under 504, and I'll point that out as we're moving on, but not that much. All right, so those are our federal laws, and there may even be in your district some sort of rule or procedure that's a little bit different. I work with school districts, for instance, that don't wait till the 10th day of suspension to start talking about an FBA and a behavior intervention plan. They mandate it at 5 days of suspension or 3 days of suspension, whatever it might be. So your own local rules may even be a little bit different. So this is the foundation of the federal rules of discipline as it relates to students with disabilities. So let's talk generally, and what I generally have tried to do over the years is start with some general propositions and then move more into specifics. So let's talk about an overall rule, just to start our foundational discussion of discipline generally. And this is the rule and the only rule that applies to all students, whether they have disabilities or not. All of them are entitled to certain rights before they can be excluded from public school for any period of time for disciplinary reasons. And this goes back to an old case that I've cited in your materials. There's a lot more to it than this, but I'm just hitting the highlights. Goss versus Lopez, way back in 1975. So this case was issued before IDEA, formerly known as Public Law 94-142. That's what we originally referred to it, the Education of the All Handicapped Children Act, which of course is not politically correct anymore, but now known as IDEA, did not become effective until September 1st, 1978. So Goss versus Lopez had nothing to do with discipline for students with disabilities. But what's important to this discussion is that Goss versus Lopez is known, for all intents and purposes, as a Supreme Court decision that for the first time basically said that education, the right to education, is a constitutional right once it's given by the state to students that cannot be taken away without affording them a certain level of due process. Some process is due before we take it away. And this is for all students, not just children with disabilities, all students. And ultimately what the court said was the amount of process due to a student depends on how long they're going to be deprived of this property right of education. And what's weird about the case, without any explanation really, the court sort of reached into the air and grabbed 10 days. 10 school days and said, you know, we think it's significant if a student is going to be deprived of this right to education for more than 10 school days. So we're going to use that as the measure and determine whether the due process that is due to a student is more significant if the student's going to be removed for more than 2 school weeks, essentially, from school. And so they set up kind of the outline of disciplinary rules saying that for exclusions for 10 days or less, the amount of process due is really just informal due process, including a procedure like at least oral or written notices of the charges. So bring the child down to the assistant principal's office and say, this is what we know you did, and then give them a chance to tell their side of the story. So that's for your quote-unquote short-term removals, okay? But for more than that, the court said, for more than 10 school days of removal of this right to education, more formal process is due. And they set up this scheme of having a more formal hearing and the opportunity for the student to secure counsel and actually be able to cross-examine and confront witnesses and have a hearing to see if the child really did it or not, to prove their innocence, giving them the opportunity to do that. So that's where all that process started, whereby states are all different in terms of how they set this up, school districts are all different, but that disciplinary hearing process that we have. And as I travel around the country, it's all different. You know, an expulsion may go to be heard by the whole school board, or there may be a discipline hearing officer. It's different in states, but that's why states and school districts set that up, was because of Goss versus Lopez, setting up that scheme of at least giving a student a hearing, giving them their right to due process before they're excluded from school for a long period of time. But that 10 days has stuck like glue, has it not? I'm not even real sure where it came from other than this decision. It's just like they grabbed it, and with respect to students with disabilities, it's stuck with us. Rule number 1 in following the Goss versus Lopez procedures is it for our students without disabilities. We have 15 more rules to talk about as it relates to students with disabilities and discipline. And I've always found it amusing. They don't do it anymore, but the U.S. Department of Ed, early in my practice, used to issue guidance that used to say, seriously, that discipline of students with disabilities is no different than discipline for students without disabilities. I still have one of those old memos. And they would say that, and then 10 pages later they would explain why. I mean, it was really kind of silly to say it wasn't different. It's completely different. It's a dual disciplinary system. So they don't even pretend to say that anymore. They know it's different. It's clearly different. And the overall reason that it's different, in my view, is for purposes of discrimination. We don't want to exclude students with disabilities who violate the student code of conduct based on that disability. That's the real underlying, I think, motivation for all of these extra rules that are set out under IDEA and generally enforced primarily by the Office for Civil Rights and obviously some courts. So that's rule number 1, that's it. for our students without disabilities following all that what I call Goss hearing procedures as it relates to guilt or innocence. Rule number 2. School personnel may consider any unique circumstances on a case-by-case basis when determining whether to order a change of placement for a student with a disability who violates a code of student conduct. This is actually the language that starts out the disciplinary section of the statute and the regulations. So that's great. This is the introductory statement. If you pull out the law, this is where it starts. School personnel can consider any unique circumstances on a case-by-case basis. Well, don't we already do that? When we're ordering a change of placement, probably for any student. And so when I saw that, and this was an addition to the law, the last time it was reauthorized, which as you well know was 2004, so that's a long time ago. But I remember when I looked at it, I thought, well, what is that supposed to mean? I'm not really sure. But what I think they intended to mean, in looking at some of the legislative history and things like that, what I think they intended was to encourage school disciplinarians to not just pick up the student code of conduct that directs, essentially, in this case, if a child does this, this is what you do. That we're going to, with students with disabilities, maybe look at all the unique circumstances and color outside those lines of the student code of conduct. That's all that I've been able to glean in terms of maybe that's what they meant, is encouraging school disciplinarians to look outside this code of student conduct and apply things on a case-by-case basis based on the unique circumstances of this child with a disability. That's all I figure that it means, but I felt like because it was added to the law that I needed to add that to one of my rules. That's what I figure it means. Not sure, never seen it interpreted, but that's the way I've interpreted it. So moving to rule number 3, sort of getting more into the heart of the rules of discipline and what school personnel can do. And I want to emphasize in my rules, when I say school personnel, what I mean there is unilaterally, without having to convene any kind of team. School personnel, when that says school personnel, that means alone. School personnel without a team may remove a student with a disability who violates the code of conduct from his or her current placement. Let's talk about current placement for a second. How do we define placement for our students with disabilities? By the services in their IEP, right? The LRE, the services, that's what's meant here. School personnel may remove a student from their current, his or her current placement as defined by the IEP to what the law refers to as an appropriate interim alternative educational setting, another setting, or suspension for not more than 10 school days. So that's the next section of when you're moving through the disciplinary provisions in the law. This is the next thing that comes up, okay? So school personnel can remove a student with a disability, violates the student code of conduct. We can suspend them for no more than 10 school days. What kind of left us hollow last time around was this burning question that still remains in my mind today. Is that 10 school days at a time, per incident, or per school year? That's something we've been kind of looking for in the law itself for a long time. The law itself doesn't say anything other than what I say in that rule. So what we knew in 2004, even though we knew that there was discussion at the federal level to try to change the mindset and change the law to 10 school days per incident, that's not what the law said in 2004. It just said up to 10 school days. So that question, when the statute was passed 2004, last time around we had IDEA, we were all asking this one. Okay, well I heard that they meant by that per incident. Oh no, I heard that they're going to stick with per school year. So let's explore that a little bit. Before we do that, however, And this is what I always ask administrators to do, because I know during my workshops, I lose them pretty early on. So I'm like, okay, attention please. If you don't hear anything else I say today, please don't forget this. The controlling question you need to always be asking yourself. So I'm a disciplinarian. Child commits this violation of the student code of conduct. I immediately think I'm going to recommend 5 days of suspension, whatever it might be. Think about this question before making any or taking any action on that decision to suspend. And this is the controlling question. Is this disciplinary action that I am thinking about, is it going to constitute a change of placement for this student? The answer to this question controls what we do next. Discipline is all about procedure, following procedure. And it's all about, in my view, whether or not we are changing the placement of this child by using typical traditional disciplinary removals. So if I'm thinking about suggesting this child be expelled from school, is that going to constitute a change of placement for this child? And I tell disciplinarians, I think this will really help a lot if you just stop and think, is this going to constitute a change of placement, what I'm getting ready to impose, what I'm getting ready to suggest for this student? And that's all great that I pose that question and ask you to keep it in mind, but I think it's incumbent upon me to make sure that I provide a little bit of guidance to help answer that question. So rules 4 through 6 are going to deal with what constitutes a disciplinary change of placement. Okay? So rules 4 through 6 hopefully will help an administrator or anybody asking themselves this question. Is this suspension, is this expulsion, is this disciplinary removal that we're getting ready to think about putting in place for this child, is it going to constitute a change of placement? Again, rules 4 through 6. So let's look first at rule number 4. Any disciplinary removal of a student with a disability from his or her current placement for more than 10 consecutive school days constitutes a change of placement for the student. And this is included in the definition section of the discipline regulations. There's a specific definition section in those regulations that defines, for purposes of disciplinary removals, what constitutes a change of placement. So we know then that any removal beyond 10 consecutive school days, essentially 2 school weeks, constitutes a change of placement, which means that stuff has to happen if it is a change of placement. Now, what we're talking about right now is just what constitutes a change of placement in terms of a disciplinary removal. It does not mean that a child with a disability cannot be suspended beyond that time, or a 15-day suspension could not be imposed. But if it is, the answer to the question, is it a change of placement, is yes. So that means stuff's going to have to happen. I'm going to talk about what that stuff is in a second, but these rules just deal with what constitutes a change of placement. Okay? What else constitutes a change of placement? Rule number 5. Disciplinary removals of a student with a disability for more than 10 days total in a school year might be a change of placement, depending on the pattern of removals. So this one is a product of the regulations that we were waiting for after the statute came out in 2004. Because I had heard from my friends at the federal level that there was serious consideration to clarifying through the regulations that it meant 10 days per incident. Because remember, the statute just says up to 10 school days, but they don't say per incident, per year, that kind of thing. So the USDOE felt it was incumbent upon them to come up with regulations to clarify the statute. But I'm not sure what kind of clarity we got through the regulations. I don't know. See how you feel as we go through this. So here is the disciplinary regulatory clarification that we got in 2006 in terms of the definition of what constitutes a change of placement if we are moving beyond 10 days in a school year. So for purposes of disciplinary removals of a child with a disability from his or her current educational placement, a change of placement occurs if the child is subjected to a series of removals that constitute a pattern because the series of removals total more than 10 school days in a school year, because the child's behavior is substantially similar to the child's behavior in previous incidents that resulted in the series of removals, and because of factors such as length of each removal, total amount of time the child's removed, and the proximity of the removals to one another. So does that clarify it for everybody? I remember reading this going, oh yeah, I remember this old language. This comes from an old memo from the Office for Civil Rights that was issued in the 80s. In fact, in 1988, I actually had to go out and train groups of principals on this. They didn't like me very much, but OCR actually started the whole 10-day phenomenon as part of 504 implementation, not IDEA implementation. We were, looking at this 10-day rule well before this language made it into the IDEA. And OCR had issued this memo in 1988, and it said, we think for a child with a disability, 10 days at a time, we know that, yeah, and if Goss versus Lopez said 10 days is significant. So any removal beyond 10 at a time, certainly, is a change of placement. But we think also that schools should consider any removals, disciplinary removals, beyond 10 in a school year to be a change of placement. And all that means is that a 504 team, in the case of an IDEA covered kid, IEP team, needs to meet for the student and evaluate the child and go through a process to make sure it's not discriminatory to remove that child. That if we're thinking about a long-term suspension, that we're making sure it's not a discriminatory suspension. It's not based on the child's disability. That's what they said. And they said, and beyond 10 days in a school year, we think is probably a change of placement, depending on the pattern of the removals. And they actually gave a couple of examples in that old memo. They said, for instance, if a student with a disability is suspended for 3 days in September, 3 more in November, 3 more in February, and the school is contemplating 3 more in May, that might not be a pattern that constitutes a change of placement, because each of those, the length of each of those removals is short term, just 3 days. The total amount of time would only be 12 in the whole school year, and they're real spread out. So we might consider the school's position that that's not a change of placement that would necessitate this evaluation by a team. However, if the child is suspended for 9 days in September, 9 more days in November, and then 10 more considered in December, that's a pattern that constitutes a change of placement. And we would expect a team to meet to go through the process to ensure that it's not a discriminatory disciplinary removal. So when this language hit the law under IDEA, I thought to myself, seen that. Now it actually made it into the law earlier than 2004. It made it into IDEA around 1997. But I remember thinking to myself, yep, I know where that came from. That's OCR's language. It's right out of that old memo that they issued in 1988. So this was really kind of nothing new as far as I was concerned, because school districts were already implementing this. But who wants to be the test case about whether or not removing this child for 15 days in this school year was a change of placement? Not a lot of school districts want to do that. So in general, what's happened nationally is an unwritten rule that we will just consider any removal beyond 10 in a school year as a change of placement? Because who wants to answer this question on a case-by-case basis? It's just easier to have one rule, and that is 10 days in the school year, we're going to consider that to be a pattern sufficient enough that if we're going to go to day 11, 12, 13, we're going to treat it as a change of placement. And remember, that's all we're talking about right now. What is a change of placement? Not that we cannot suspend a child with a disability beyond 10 days in a school year. It means if we do, it's a change of placement, essentially. And you could color outside the lines if you choose to do that based on the pattern of removals and that kind of thing. The new language to 2004 was this whole thing about whether the child's behavior is substantially similar to the child's behavior. So I guess some sort of pattern, if it continues to be the same behavior, there's more chance that it is a change of placement. Not real sure. But suffice it to say, that one is tough. So again, most schools across the country don't want to be the test case for when moving beyond 10 days of suspension in a school year are or not a change of placement. It's just easier to implement a clearer rule that says pretty much any removal, disciplinary in nature, of a child with a disability beyond 10 days in a school year is a change of placement. That's all we're saying. Not that it can't be done, it's that we have to follow and do some stuff because it is a change of placement. Rule number 6, and I added rule number 6, I'll never forget when I added this one, because I came across an old case, one of the very first cases on page 4 of your materials, the Sherry case. The Sherry case was an interesting case because the school put the child out on short-term suspension. They just didn't let her know when she could come back. The court said, oh no, we see that for what it is. Don't call it something it isn't. So rule number 6, in counting our 10 and when a change of placement actually is going to occur, disciplinary removals of a student with a disability that are not necessarily called suspension may still likely be counted as change of placement days for the student. So that brings to mind what I call the constructive eviction suspension. This is not a suspension, Mom and Dad, but please keep Susie home for 5 days for a cool-off period. Now, I know these things don't happen in Indiana. I'm just giving you some examples of what happens in my jurisdiction. Cool-off period, home time out, happy home time with Mom and Dad, whatever we call it. I got a call one time, oh no, we didn't suspend her, we put her out for mental health leave. I said, for you or her? Let's talk about that, okay? Don't come back without Mom and Dad for a conference. There are actually laws in our state that say that if a child is suspended for a certain period of time, the parents must return the child to school for a conference, that re-entry conference. Well, what if we know Mom and Dad are nowhere to be found? We know the kid's not coming back till Mom and Dad come. Okay, same sort of difference. Don't come back without your medication. Again, I know that would never happen here. Okay. You need to come up here and get him every day at noon. We just can't handle him in the afternoons. The U.S. Department of Ed has recently issued a letter, 2019, basically saying half days could count. You know, I've actually seen the Office for Civil Rights in action on this one, where they get the files and the investigator sits down and actually counts all the days, half days, computes them as days. I've seen that happen. Don't come back without a psychiatric evaluation. This was a case out of Massachusetts where a federal judge said, no, same sort of thing. When the principal said to the parents, don't bring him back to my school without a psychiatric evaluation that gives him clearance to return, and he needs to be on antipsychotic medication. Court said, same thing. If you don't agree to keep him home, we'll have to call the cops. So what choice does the parent have, really? So in those kind of situations, that could be byproduct is, resulting is a change of placement. So we have to be careful about some of those what I call constructive eviction suspensions. All right, that was rules 4 through 6. That just defines what is a change of placement. So we know then what constitutes a disciplinary change of placement. Now what? What does that mean? Okay, if the answer to that controlling question is, yeah, these 5 days I'm getting ready to impose are going to constitute a change of placement because he's already been out for 10 this school year, so I'm worried it could be a change of placement, let's play it safe. Well, what does that mean? What do we do now if we want to move to an expulsion or 5 more days or whatever it is? Rule number 7. This is straight out of the language of the law itself. See if you see any inconsistencies here. School personnel have the authority to remove a student with a disability from his or her current placement for up to 10 school days and for additional days for subsequent incidents, as long as a change of placement doesn't occur. Let's look at that a little bit further. This was new language that came out in the 2006 regulations. Again, clarification from the regulations, right? Because, again, all the statute said was up to 10 school days. So this was all about the regulations, coming up with these regulations. Let's clarify for school personnel what we mean by this. School personnel, and this is exactly what the regs say, bears repeating. School personnel, again, without an IEP meeting, without a 5014 meeting, may remove a child with a disability who violates a code of student conduct from his or her current placement for not more than 10 consecutive school days, and for additional removals of not more than 10 consecutive school days in that same school year for separate incidents of misconduct. So had there been a period right there, this whole 10-day rule thing would have changed. But as if to hide it, the US DOE put it in parentheses, as long as those removals do not constitute a change of placement. So this is why I like to talk to you about what constitutes a change of placement first before we get to this regulation, because we need to know what that means. So now we're back to the 10-day thing, aren't we? The definition of a change of placement is any removal beyond 10 consecutive at a time, or any removal, give or take, depending on the pattern, beyond 10 in a school year. So this language is really not terribly helpful. It puts us right. But when school administrators, and I've had this experience, when this language came out in 2006, my phone was ringing off the hook. Administrators that I knew calling me, Julie, did you see it? Did you see what the law said? It said we get 10 days at a time per incident. I said, whoa, hold on. Let's get that out and read it together. See that little piece in parentheses? As long as, oh yeah, okay, you can have the first 10 for an incident. So now you're moving to your second 10 for an incident. That's 20 total days. Now you got to determine if it's a change of placement. My guess is it is. So no. It sounds good, but I hate to tell you this, it doesn't really say what it seems to say. And I was really disappointed actually for administrators, not necessarily for children, because I think IEP teams need to make all these decisions, frankly, but I understood because there was this huge lobby and it was political. It was a huge deal. And I remember this whole thing about the 10 days in the school year being a really big issue when IDEA was reauthorized in 1997. I have a really good friend who represents a lot of school districts in the state of Mississippi. And he pretty much does mostly special ed work. And he was called upon by Senator Trent Lott, who at the time was the head up of reauthorization in 1997. And apparently Congress was being heavily criticized because the statute did not address this more than 10-day thing. And school administrators, superintendents, school board organizations were very critical. And they were attacking the U.S. Department of Ed, they were attacking Congress, and Senator Trent Lott said, I thought we did what we were supposed to do. And he was kind of heading up the whole 1997 reauthorization to IDEA. He called on my friend to go to Washington and sit down and explain this law to him. Now, this is scary, that the senator who was up really trying to guide what needed to happen under IDEA is calling on a friend to come in and explain this law. And usually when a senator invites you to their office for a discussion, you meet with their staffers. I don't know how many of you have had that opportunity, but it's very rare that you get to actually meet with the congressperson or the senator in this case. So he arrives, and Senator Lott actually had a meeting set up. And there at the meeting was a fellow known as Tom Hare, who used to be the director for OSEP, the Office for Special Ed Programs. And his boss, who is head up of OSERS, the Office for Special Ed Rehab Services, Judith Heumann. And we used to call it the human hair factor. I remember that. It's like, oh, the human hair is back at work. And they were the US DOE folks for IDEA, basically, making all the policy decisions. Senator Trent Lott was there. My friend walks into this room. And they had this discussion, essentially, about who are children with disabilities in schools. And at some point along the way, they're having this discussion about how difficult this all is to manage, particularly when you're dealing with dangerous students and you're restricted to the 10 days and all of this kind of stuff. And Senator Trent Lott kind of stopped the conversation. And he said, does this law apply to students who have, like, learning disabilities and behavioral issues and things like that? I thought it only applied to students who are really, really, really disabled. And he kind of looked at Judith Heumann. She was in a wheelchair. And it was almost a insinuation, like you, kind of thing. I didn't know it applied to all of these other students. I mean, what's going on? It was really scary. This was a scary story. Now, this is a lot of rumor to it, but it doesn't surprise me. And actually, Senator Trent Lott said that he was going, and he turned to the human hair factor, and he said, if you don't change the law to make it very clear that school administrators can use 10 days of suspension per incident, I'm going to take it to the Senate floor as a statutory amendment. 2 years later, we got this language. And I think it's actually pretty brilliant because it kind of looks like 10 days per incident. Until you look at what's in the parentheses, what? We got to look at whether or not to use 10 days per incident is a pattern that constitutes a change of placement. And sure enough, pretty much when you move beyond 10, moving down to day 11, 12, 13, it's hard to say it isn't in many circumstances. But it was brilliant to me how they even put it in parentheses to almost hide it in a way so that everybody, including Senator Trent Lott, who thought the law only applied to really, really, really disabled students, not really disabled students, just the really, really, reallys, here we are. So this is why whether Congress, and he thought this took care of it, and he moved on, and Saddam Hussein got involved in all of the stuff going on around the world, and they were looking at other stuff. So we really still have this 10-day rule, even though this language in it, and I get called on this language almost every single day. Special ed directors pick it up, they'll read it and go, Julie, wait a minute, the law actually says 10 days per incident. I'm like, let's go through it. Because the change of placement, that language, the definition of change of placement is in a whole different section. It's several pages over if you have your little regulations out. And that was all intentional in my view, in order to satisfy Senator Trent Lott, make him go away on this, but keep this. So that's why we do have this more than 10 days in a school year. Of course, we got that pattern language, so give or take is a change of placement. So I've got this case in my materials and actually thought about taking this out, but I feel like I've got plenty of time to cover all of this, but I take it out sometimes because I don't trust people's interpretation of it and what I say about it. So with those cautionary provisions, I'm going to talk about just this one case. There are not a lot of cases in discipline, particularly as it relates to movement beyond the 10 days and that kind of thing, because most of the time, if a school district is called on it, the district just settles the matter because we don't feel comfortable enough about it, or probably, as I told the group yesterday when we were talking about manifestation and why there's not a lot of law that's clear guidance with respect to help in that regard, particularly in the area of discipline, is I think if you choose to go to battle over a disciplinary situation, by the time you get through the court system, you've forgotten what happened in the first place. The kid's already graduated. Who cares anymore? You know, that kind of thing. And so we don't get a lot of case law with respect to certain specific propositions. But I'm always on the lookout for cases where the school district kind of went beyond the 10 in a school year. What did they do? Did they do it right? How is that all interpreted? So in this Joshua S. case, and this is just a federal district court opinion, I've seen it cited a good bit over the years, but a Florida district court opinion, so certainly it's not a binding at all in Indiana. But I will say that, especially in special education, the courts do give a lot of deference to each other. And I learned that lesson when I was trying a case in federal court a long time ago, and I cited some sort of proposition, and the judge looked over the bench at me and said, well, I found, of course he didn't do it, his clerk, found a opinion from a hearing officer from Iowa that says so-and-so. And I went, oh my, that means I'm going to have to read everything that comes out, because it might be persuasive in this area where courts don't feel comfortable. And so everything is, to some degree, persuasive in this area. And so I've cited from far away jurisdictions in cases that involve students with disabilities, because federal judges want anything they can get that might be some authority. So for what it's worth, this really just is an example of a pattern of suspensions that the court felt was a-okay, so to speak, that did not violate the provisions of the law, holding that it really was not an illegal change of placement when the student was removed for a total of 26 days. And this was by the holiday break. Okay? So many of us want to celebrate, but remember what I said, if you're celebrating during my comments this morning, and then there's a mistake being made, hold on a second with respect to that. Because it's important to look at what actually happened in this particular case. And I hope you can see these. I don't know if you can or not, but this is just kind of a rundown overview. So they start with this young man who's in middle school. He's seriously emotionally disturbed. That's his identification. He's receiving special education services in a middle school specially designed program for emotionally disturbed students. And they had what they called the inner loop of this program and the outer loop. The inner loop was the most restrictive of the two. The outer loop was for students who were kind of able to be mainstreamed to some degree, so it was less restrictive. Well, this year comes along and the team had decided that they were going to move him based on good behavior from the inner loop to the outer loop. Okay. So they start off the school year on August the 30th by having an IEP team meeting, because one of the things that he had problems with was leaving class without permission and just overall good behavior. They wanted to start things off right in the outer loop. So they start with a meeting and they develop this behavioral path system for him. Okay? Within about 2 weeks of school, he was engaged in an incident. He had a meltdown, took off his belt, went outside and started just threatening people with it, going to injure everybody in sight. The school detective takes him home. Okay? Just, well, we need a little bit of home time out here, takes him home. The team meets the next day to revise that pass system, because he got involved in this by leaving class without permission, just taking off and just having this meltdown that became violent. So they revised his PASS system. Something didn't work there. Let's sit down and take a look at this with this incident in mind and revise this PASS system. About 2 weeks later, he received a timeout for refusing to leave class. So he liked it both ways. I'm going to leave without permission, then when someone tells me to leave, I'm not going to do it. All right? Next day, he gets a 5-day suspension for defying staff generally, use of a lot of profanity, gets a 5-day suspension. 5 days later, the school psychologist meets with the parents and says, you know, we're seeing a few things that seem a little different about him this year, some unique behaviors. I'd like to conduct an evaluation. And the parents said, oh yeah, by the way, we think that he's been diagnosed with Tourette syndrome, so you probably do want to take a look at that, so we're agreeable to that evaluation. So they decide that they're going to do a re-eval. November the 5th, he's sent again to the principal's office for use of profanity, sent to the office 3 days later again for timeout. On the 11th of November, they have a parent-teacher conference, not a formal IEP team meeting, but they discuss the results of that evaluation. They're like, oh yeah, we need a full IEP team meeting. We need to make some decisions here. Let's have an IEP meeting, and they scheduled it for a week later. In the meantime, though, he gets another 5-day suspension for the use of profanity again, walking out of class. His father's called to come pick him up, again, that suspension. Then 6 days later, they have that IEP meeting that they had actually scheduled. Because they had reached their 10 days, they went ahead precautionarily and took the effort to, as part of this meeting, make a manifestation determination. They said, yeah, we think all of this that's been going on is a manifestation. However, we think he needs more supports. He's not doing well in the outer loop. We propose a change of placement for him to move now back to the inner loop program. And then they completely revised the behavior management system, came up with a new behavior management plan for him at this particular meeting. On December the 1st, about 2 weeks later, there's actually an in-service done because they did find Tourette syndromes. They did an in-service specifically for staff to try to address those unique behaviors when there might be that he's suffering a little seizure, whatever it might be. 5 days later, he's involved in a very dangerous incident where he puts himself up on a high wall outside the school. He's screaming, threatening people, threatening to kill himself. He received a 10-day suspension. The resource officer said, if this happens again, I'm going to arrest you. The principal reduced the suspension to 6 days. And also, mother picked up his school assignments so that he could keep up with his schoolwork. So the day after, they ask her to come by. She picks up school assignments. The teacher's checking in with him during this suspension, the 6-day suspension. Another 10-day suspension for another out-of-control behavior. This time the sheriff was called, and as promised, the student was arrested. Parents had had enough and filed for due process, saying, look at all these removals. You have done this incorrectly. You have violated the law. This was all a change of placement. You didn't follow the right procedures. And the court looked at everything and said, well, once they got to the 10, they did a manifestation determination. In the meantime, they're having meetings. They're developing behavior management. It's not like they're sending this child home out of sight, out of mind. They're meeting all along the way. The decisions are not made by school personnel necessarily. They're made by a team. Then after the 10 days of suspension, the child is moved to the inner loop and they changed his placement. They didn't further suspend. They didn't further expel. And essentially the law says that you can, quote unquote, change the child's placement for up to 10 school days for violation of the student code of conduct. So they had, for what it's worth, that new placement in the inner loop, you technically get the 10 new days there. And they followed all the rules. They involved the team. They behavior managed. They did a re-eval. They did a change of placement in the meantime. So technically, they followed the rules as it relates to the use of disciplinary removals. And when you really sit down and look at it, they did. But I'm real careful when I talk about this case, and I think I can trust you all to understand the point is that it's the unilateral sending kids home and doing nothing in the meantime that's the problem. If you keep the team involved, it's all a matter of jumping through these procedural hoops, making sure that the team is making the change of placement decisions for the most part. And they were not changing a child's placement for more than 10 days, give or take, when you're talking about, cumulative days in the school year. Just being very careful to always rely on that team to get involved. That's what this stands for. But these kind of cases are few and far between. This is actually the only one I've ever been able to find that really gives us an example of how the language has all been interpreted it. But to me, the bottom line is IEP teams need to be doing this, not disciplinarians using disciplinary removals and getting them involved in program management for the child through the IEP process. Okay. So it is all about getting through those procedural hoops. So what are those procedural hoops? Well, we've already visited some of them by way of that case study, but rule number 8. We are all very familiar with that one procedural hoop, and that is the MDR, the Manifestation Determination Review. Some people call it the MDH, Manifestation Determination Hearing. I don't see it as a hearing where you're taking evidence or anything like that, so commonly refer to it as the MDR or whatever. You might call it the manifest, whatever you call it. It's that within 10 days of our decision that we're going to pursue a change of placement using disciplinary removal. So the principal says, is this going to change the child's placement, this expulsion? It is, but we're going there. So we're going to head down that road. Within 10 days of making the decision we're heading down that road, we've got to conduct a manifestation determination. And I did a breakout session that dove very deeply as I could do it based on case authority and everything else that's out there yesterday on manifestation determinations. If you didn't come and you want more information, my handout is pretty comprehensive if you're interested in that issue. But that was sort of a sub-issue. This conference has sort of become a discipline conference for me in terms of my themes. So manifestation was one of my breakouts. This afternoon I'll be really delving into options for dealing with dangerous students a little bit further beyond this presentation. So when do we do this MDR? It's one of our procedural hoops. If we're going to change the placement using a disciplinary removal, for example, we're going to expel this student, then we can only do so if we have our manifestation determination within 10 days of deciding that we're going that route. Okay? So what does an IEP team ask to determine manifestation? Hopefully you're all familiar with these questions. More often than not, these questions actually come out in the form of a form that's used by every team, so you can check to make sure you're asking and answering the right questions. But these, again, straight out of the law, if you're following along in the handout, that's page 5. Was the conduct in question caused by or did it have a direct and substantial relationship to the child's disability? This was a big change last time the law was amended. It used to say things like, did the violation of the student code of conduct and, did the child understand the consequences of that? Did the child's disability impair the ability to understand what the child was doing, that kind of thing? Now it's no. Was the conduct a direct and substantial? Was it caused by, directly and substantially, by this child's disability? And was that conduct the direct result of the school system's failure to implement the IEP? Previous language was the conduct in question, no, it wasn't even that. It was actually, did the school fail to implement the IEP? That was it. Now it's causation. Was the failure to implement the IEP a cause of the child's violation of the student code of conduct. And that makes a difference, because before, if we found, let's say, the child had not been receiving speech services for 6 weeks, and the child commits a violation of the student code of conduct, we would have to say, oops, we weren't implementing the IEP, case closed. Now the question is, was the failure to deliver those speech services the reason the child brought the gun to school? So it's different. And what Congress was trying to do there was rein this in, so that there would be less opportunity for teams to find that there was a manifestation. So since 2004, have you all seen a lot of change with respect? No. But that was their intention. That was the intention, to tighten this up. And I will say that some of the lawyers that I work with who represent families did not like this change, feeling that they had restricted it too much, requiring parents to show that direct and substantial relationship. So obviously, if the answer to either of those questions is yes, the conduct is considered to be a manifestation. If the answer to the second question particularly is yes, then the school system needs to take immediate action to remedy the deficiencies in implementation. Okay? So we made our manifestation determination. We've gone through all of that. And yesterday in my materials actually set forth a summary checklist of factors that might be helpful to teams in making the manifestation determination. But it's a tough thing to do, as you well know if you've ever been to one of those. And I know many of you go to lots of those. So we make the determination. What difference does it make? So that's rule number 9. Where the student's behavior is found to be a manifestation, the IEP team shall ensure that the functional behavioral assessment and the BIP, I call this the FUBA and the BIP stuff, those things are done, and return the student to the placement from which the student was removed, unless the parent and the school system through this process actually agree to a change of placement. You know, the IEP team can always agree to a change of placement, right? We're talking about, though, the unilateral, we're going to expel this child, not through the IEP team process, because no, we don't do it that way. We're doing it through the disciplinary removal process, and if we're going to do it that way, and we find it to be a manifestation, essentially, no can do. We've got to do the FUBA and the BIP stuff and return the child to the placement from whence the child came. Okay? So what if the school has already done a functional behavioral assessment and a behavior intervention plan? The law contemplates, and the IEP team then needs to meet only once to review and revise the behavior intervention plan. My hope is that if we've gotten to that point of having to sit down and make a manifestation determination because we've already used 10 days in the school year, we've already done a functional behavioral assessment and a behavior intervention plan. There's further motivation to do it before we get to the 10 days, but unfortunately the way the law reads, the FUBA and the BIP stuff don't kick in until we are making a disciplinary change of placement, which I think is a terrible mistake in the law itself. Should kick in way before the child has used up those 10 days and we're considering a disciplinary change of placement, right? So remember though, manifestation determinations, all of this stuff is triggered when we have decided that that's the road we're taking, okay? That we are going to stay in the disciplinary world because this young lady with a learning disability in math who brought marijuana to school yesterday, we clearly know it's not a manifestation, so we're going down that road, okay? So we can. But we need to make sure that we feel comfortable with the manifestation, because that's going to be at the end of this road, that we're not going to have to put her back at the school where she brought the marijuana, whatever it might be. Rule number 10, even when no manifestation is found and placement is changed. Okay, so the presumption is, if it's not a manifestation, we can go ahead then and change the placement using a disciplinary removal. So when we do that, it's important to note that the student still must continue to receive FAPE during the disciplinary removal period, and if appropriate, the FUBA and the BIP stuff is done. Okay? So just because it's not a manifestation doesn't mean that we can pick up the student code of conduct and see what a child without a disability would get if they committed this offense and just impose it. It means we got to figure out what this child's going to get in the meantime. And that's where the real double standard comes into things, because you could truly expel a student without a disability with nothing unless your school district or state prohibits that. But you could never do so for a child with a disability under the IDEA. For a 504 only kid, note to self, it's a little different. OCR has acknowledged it's a little different. Okay? If you would not provide anything to a student without a disability for the same offense, OCR has acknowledged that you wouldn't have to do so for the 504 only situation. But for our IDEA kids, FAPE continues. Notice I have FAPE in quotation marks because we are always concerned about what the heck FAPE means in that circumstance. So on page 6 of your materials, under rule number 10, I have a little bit of explanation with respect to what that is. And it says the child shall continue to receive educational services so as to continue to participate in the general curriculum and so forth and so on. Okay? Whatever that means. That's tough, and basically a team, though, is going to have to decide what that continued FAPE is all about. I'm going to talk a little bit more about that after Rule 11. After a student with a disability has been removed for disciplinary reasons for 10 days in a school year, the student still continues to receive FAPE too. So on day 11, 12, 13, and 14, even if we decide it's not a pattern, not a change of placement, or ultimately we find it's not a manifestation and we're going for a 20-day suspension, the child is going to have to receive something called FAPE. So we might as well go ahead and treat any removal beyond 10 in a school year as a change of placement, because we're going to have to provide FAPE on day 11, 12, 13, and 14 anyhow. So that's another practical reason that we probably adhere to that rule. So let's talk about more specifically, what FAPE actually is. Here's the language that I list there under rule number 10, talking about what FAPE is during these removals, and assuming these are appropriate removals, to enable the student to continue to participate in the general curriculum, although in another setting, and to progress toward meeting the goals set out in the student's IEP. So we've got a little bit of commentary from the U.S. Department of Ed regarding what that means. And this came out as part of the regulatory commentary in 2006, where the U.S. DOE was asked by numerous stakeholders, what does this FAPE mean? What's that supposed to look like? So they come out with this guidance that says, we believe the Act modifies the concept of FAPE in these circumstances. School districts are not required to provide children suspended for more than 10 school days in a school year for disciplinary reasons, exactly the same services in exactly the same settings as they were receiving prior to the imposition of discipline. I told the group yesterday, I tend to refer to this as fake FAPE, faux FAPE, maybe a little bit more politically correct, but it's a form of FAPE? I don't know. So are there any cases about that? So I have searched for years and years about a situation where the parent is objecting to the services provided to an otherwise appropriately expelled child. And my go-to case, and I've actually used it in a couple of due process hearings I've had, is the Farron case. It's the only one I've been able to find. It's in your materials there on page 7. It's not an Indiana case. It's out of Maine. But I've had other hearing officers look at it and accept its principles, and even a court in one instance. So this Farron case, long story short, involved a middle school student who was caught selling marijuana in the bathroom. A lot of bad stuff happens in bathrooms at school, apparently. A lot of disciplinary infractions. Interesting thing was, he was with a group of other kids. It was sort of like a marijuana ring going on in the school. And he was actually serving as the delivery boy. He would take the drugs to the buyers, and then he would take a cut of the money as his delivery fee. So the principal discovered this activity going on and recommended that all of the kids involved be expelled. Okay. Well, because this kid was different, because he had a disability, he had learning disability in math and reading, I think, if I recall correctly. Ultimately, mom said, oh no, he can't be expelled. Oh, whoops, you're right. So they had to sit down and do a manifestation determination, and they felt like that behavior was not linked to his learning disabilities. And they found that it was not a manifestation. In that school district, they said, so we're going to expel him to the alternative school, which I find to be an oxymoron in terms of expelling to the, I thought expulsion meant you're getting nothing. No, we're basically moving him to the alternative school. And alternative schools get a bad rap these days. We need to shift that focus a little bit. Maybe it's better in Indiana than in my jurisdiction, but sometimes alternative school is thought of as the place where all the bad kids go. It's a disciplined setting, instead of maybe just a smaller structured setting, which really I find many times it is different than it used to be in the olden days. But he was expelled to the alternative school. Mom agreed at the meeting with the no manifestation determination until she met up with a lawyer, and they decided to challenge the entire thing. So she challenged it on the basis that it wasn't a manifestation. The court disagreed, but she challenged it primarily on the fact that at the alternative school, the student didn't have access to the same courses that he had had at the middle school where he was selling the marijuana. And the court said, well, I don't think that the program needs to be exactly the same. The child was at the alternative school able to participate in the general curriculum to earn credits toward 10th grade. He was a 9th grade student. He could still earn some credits. Maybe not as many as he would have earned if he wasn't engaged in this marijuana activity in the school, but he's still going to be able, under Maine's curriculum, to earn credits, etc., and upheld it as an appropriate FAPE for the student. So for what it's worth, it's one case out there that might provide some guidance if you have one of those scenarios or that particular question. It's all I've been able to find really that's terribly helpful with respect to this. So now I'm going to venture into, wrap up these rules quickly. Are there special rules for dangerous or disruptive students? So all these procedural hoops we've talked about, we want to deal with a really dangerous child. You clearly know there are. Rule number 12. However, there are some exceptions, but in general, no matter how dangerous or disruptive a student is in general, we still cannot bypass the disciplinary change of placement procedural hoops. That's the general rule. And this was the general rule that was established in 1988 by the Supreme Court in a case called Honig versus Doe. And if you have never read Honig versus Doe, I highly recommend it just for giggles. It's not a very long case. It's a pretty easy read, and I know all of you have so much free time on your hands. You can head over to a law library and get a copy of it. But way back in 1988, the Supreme Court in Honig versus Doe was dealing with dangerous students with disabilities, and there was an argument that there ought to be an exception to all of these rules of having to call on an IEP team, do a manifestation determination. You ought to be able to move that dangerous child right away, and then all that stuff can happen. But the child needs to be out of the school setting. And the Supreme Court said, well, that's not what the law says. There are no exceptions. Back in 1988, there were no exceptions to stay put and all of those kinds of things. And the court said we are bound to interpret what Congress has written, and Congress doesn't have any exceptions. So sorry, there are no exceptions. However, the court did say, and this would provide a lot of relief to everybody, and you probably want to write these things down. The court said this should not be a problem for school administrators because there are lots of things you can do with students who are dangerous. You can use study carols. Works every time, right? You're not writing these things down. Study carols. Time out. Yeah. Detention. I love that one. Let's keep them around a little longer to be dangerous. In the afternoon, maybe even on a Saturday. Really? Restriction of privileges, or more drastically, you can suspend them for up to 10 school days. But we're not going to write anything into the law that Congress doesn't have there, so sorry. But what Honig did say was that schools could seek a restraining order. We could file a lawsuit against a parent who had challenged the removal of a dangerous student and invoked stay put. We could challenge that by going to court and asking for help. We can't unilaterally move that student, but come to the generous courts and they will give you a restraining order or an injunctive relief to get that dangerous child out. So that's what we were stuck with in 1988. And that's when Congress decided, okay, we see schools, folks across the country, we hear you. We're going to carve out some exceptions for maybe jumping through those hoops after the fact. Give you immediate relief in the schools. You can move certain students. And they created what I call the special circumstances. Rule number 13. School personnel without an IEP team being involved may remove a student with a disability to the IAES, interim alternative educational setting, for not more than 45 school days without regard to manifestation. Don't even have to worry about asking if it's a change of placement, manifestation, if the special circumstance involved weapons, drugs, or serious bodily injury. I still today, even though this provision has been around for a long time, now the last revision added serious bodily injury. We had weapons first, then drugs came along, then serious bodily injury over the years. But I still see a lot of misinterpretation and use of the 45-day rule, particularly as it relates to the fact that it's only these circumstances. Right now in Florida, I get a call every day. So we moved the child to the 45-day interim alternative setting because they threatened online to kill somebody. I'm like, threatening is not sufficient. That's the problem. This is only the 3 circumstances set out under the law. And if you look at the language, it's not terribly helpful on page 8, particularly as it relates to, what the definition of a weapon is. And if you're interested in this, I'm going to be spending a lot more time on this in my afternoon session. If you don't come to that, my handout's pretty comprehensive as it relates to that. But I love the one on drugs. Knowingly possesses or uses illegal drugs. What's the first thing the student says when you find the drugs in the book bag? I didn't know that was there. The knowingly piece. I mean, we're going to have a whole hearing on just whether or not it was knowingly. So the language is not terribly helpful there, but we do the best we can with it, and it does provide some assistance. But the big problem, what is that interim alternative setting going to be? So that's another big problem that has to be determined too. Rule number 14, anytime a parent disagrees with a disciplinary removal, or if the school system finds itself in a circumstances where we can't keep this child in the current placement, then either can request a expedited due process hearing in situations where we feel it's substantially likely to result in injury, or if the parent just disagrees with it. So if it's a disciplinary decision that the school has made, the due process hearing procedure is expedited. And there's a process for that. What is an expedited hearing? It must occur within 20 school days. Instead of the typical school days of the date the hearing is requested, must be decided within 10 school days after the hearing concludes. So it's just compressed timelines and getting it done much quicker because in the meantime, the student is out. Okay, that's what the revisions in 2004 basically said. And a hearing officer can only, in an expedited hearing, either order the return of the student because the school didn't do things right, didn't follow the right procedures, made an incorrect manifestation determination or whatever, or order the change of placement to an appropriate interim alternative setting, but for not more than 45 school days. So some are actually finding that an expedited hearing is not expedited enough. And some schools are still going for Honig injunctions to get the child removed immediately if we're in a procedural quagmire or whatever it might be. And lastly, when a hearing is initiated, where does the student go? This was a big change in the law in 2004. It used to be anytime a parent requested a due process hearing to challenge anything, stay put kicked in. But if it's disciplinary in nature, the student will be wherever the school decided the child will be pending the due process hearing. So that was a big bone that Congress threw to schools saying, use this carefully. Okay. All right, so those are our rules. Oh goodness, look at the time. Aren't we having fun yet? So that's clear as mud, right? And I apologize for that, but that's the best I've been able to do to try to make sense of it and try to come up with some rules that just kind of confirm what our understanding is overall of the general process for disciplining students with disabilities. Now, how do we apply it in individual situations? So I'm going to move through these practical implications fairly quickly. Let's see, I have till 10, is that correct? All right, just making sure yeah, I got plenty of time. So let's talk about some of frequent questions that I get. Transfer of student to another school site. As a disciplinary move, is that a change of placement? And generally, as is usually the case, the answer is it depends. But there is some authority that I have cited in your materials there that talks about, and there's a lot of this, there's a lot more case law that supports this notion that merely moving a child, the change in brick and mortar only, is not necessarily a change of placement. So for my small school districts that I have only 3 schools, that's not going to necessarily be of help. But in a case, let's say, where a student for disciplinary infractions is moved from one high school to the other, and nothing about the IEP changes, it's just a site change, that would not necessarily be a change of placement. But you're going to have to really look at that to make sure you feel comfortable that that's the case. And so, and there are some states that will say a change in site is also a change of placement. California is one of those. I don't think Indiana is, but California is. So what about the school bus? This question comes up. How are bus suspensions counted toward a change of placement? The US DOE has said this is very clear. It depends. What does it depend on? Remember, back to that old question. Is this bus suspension that I'm thinking about imposing going to constitute a change of placement for this child? And the U.S. Department of Education has said that change of placement requires us to look at the services in the IEP. And if transportation is provided as a related service for a child with a disability, if we take it away, that's 1 day of a change of placement, right? And I've quoted the U.S. Department of Education here, bottom of page 10 over to 11, where they talk about if it is a related service, that it's specially designed in some way, it's needed for the child's disability, it is on the IEP as a related service, then it's part of the child's current placement. But if the child, according to the U.S. Department of Ed, walks to the bus stop, as non-disabled children in the neighborhood do, gets on the bus, rides the regular bus because this is a privilege that is offered to all students in that school district, and there's nothing special about it, then it's not necessarily a related service for that child. And the parents, they go further. The parents and the student have the same obligation to get the student to school as a parent of a non-disabled child would be who's been suspended from the bus. But OSEP goes further to say, however, if it's like chronic behavior on the bus, that's the same kind of behavior that we see in the school program that we're programming for, then perhaps we should have something special about transportation for that child. So cautionary there. Okay. So it's always fun to train bus drivers and other transportation folks on this topic. I remember a room full of transportation folks for a very large litigious district I was training for, and I was actually frightened by the looks I was getting, like someone's going to hurt me before I get out of here, but I'm just the messenger. What about in-school suspension? In Indiana, do you call it in-school suspension? General term, ISS, in-school suspension? Again, that clear answer, it depends. But the U.S. Department of Ed has actually said this is their long-standing position on this. Days of in-school or in-house suspension are going to be counted depending on what services are provided in that setting. And they go on to say if the child is still receiving the services in the IEP, if the child is still being served in the least restrictive environment, so participation with non-disabled students hasn't changed, and the child is still participating in the general curriculum, they say it probably wouldn't count as a change of placement day. So it all depends on what's going on. Years ago, I was actually doing a presentation for a group of administrators in Tennessee, and I told them that I prefer we didn't call it in-school suspension, because the word suspension in the land of special ed law connotes a change of placement day. And if we're continuing services, let's don't call it suspension, because we're not suspending the student. So let's come up with a different name, like the opportunity class, or the STAR program, or whatever it might be. And I saw a couple of administrators in the back of the room, they were talking and they were laughing together. And I'm like, oh, no one laughs in my workshop. So I had to check in with them. What's going on? Why are you guys smiling back there? And they're like, oh. I said, well, since you are having a good time, could you share with the rest of us, because we aren't. And one of them sort of sheepishly said, well, we just came up with a new name for our in-school suspension class. I was like, oh, okay. Want to share it? Yes, it's called the Helping Everyone Love to Learn class. And I said, okay. And by acronym, it's HELL. You go straight to hell, and that's not a change of placement. I'm like, okay, all right, well, let's see what's in hell, you know. But that's what they said. I didn't say it. But in any event, I thought, okay, no, let's don't get that creative. But why do we call it in-school suspension? If we're not taking services away, that's something that we really need to think about in our lingo, because parents think one day of suspension counts toward the 10 and change of placement and all that. So just something to think about. Some other miscellaneous issues, partial day suspensions, I've already talked to you about that. Half days, sending students home early, that kind of thing. This is a question that I got over a number of years, and I never had an answer to it until there was actually this case in the middle of page 12. So hey, I'm hanging my hat on anything I can find. But this was my thought about it. Sending a student home for head lice or something like that. Is that a change of placement? And my gut was, it's not disciplinary. It's a situation that needs to be resolved because it could be harmful to other students and staff. And this kid was suspended, not suspended, but sent home for head lice to be treated for more than 10 days. And the argument was, you can't do that. And the court said, doesn't apply. This is not a disciplinary removal. It doesn't apply in that situation, for what it's worth. Discipline of students attending summer school. Well, summer school, I think it depends on whether or not it's part of the child's IEP and therefore part of the child's placement. That's my story and I'm sticking to it, but you might want to see this New York case at the bottom of page 12 that talked about and equated summer school to extended school year. See, I think they're two separate things. So I think that court was wrong, but the court's never going to listen to me anyway. So I do have an obligation to let you know that New York case is out there. Students attending programs operated by other agencies in public school buildings. So let's say the Boy Scouts want to use one of your school buildings for Saturday meetings, troop meetings, whatever it might be. But the Boy Scouts don't let that autistic student come or whatever it might be. Is it discriminatory for us to continue our relationship and let them use that building? Yes. So we have to be really careful. Even though another agency is operating it, we're still supporting that, so that could be a problem. What about regular ed students in the evaluation process who haven't been yet identified? You know that provision under the law. Regular ed students can assert the protections of the IDEA if the school system had knowledge the student was a student with a disability before the behavior that precipitated the disciplinary action occurred. So it requires us to sort of look into a crystal ball and look to see what did we know at the time about this particular child. And that really comes up in the context of a situation of child find, that we missed something with respect to this particular student. But specifically in terms of when a school system in a disciplinary context will be deemed to have knowledge, the law sets up a couple of instances that will be legally deemed to impute knowledge upon the school district to treat the regular ed student as an IDEA covered kid. If the parent expresses concern in writing to any supervisor or administrative personnel or a teacher of the student that the student is in need of special education related services. I often play devil's advocate, and I often think about, hey, if I were a parent of a child, beginning of every school year, I'd write a letter that I think my child has a disability. Because that expresses concern. It doesn't even say legitimate concern or a concern that has any basis behind it. It just says in writing a concern. If the parent has requested an evaluation, well, when? 10 years ago? There's no time limit there. There's no period time, nothing like in the last year, or what if we actually did one recently? If the teacher of the student or other school personnel express specific concerns about a pattern of behavior demonstrated by the student directly to the director of special ed or any other supervisory personnel. So the custodian for the school sees this child wildly run through the hall, the principal's standing right there, and the custodian said, I'm really, really concerned about his behavior. He does this all the time. Is that enough? Probably not, but the way it's worded is so vague. There are so many arguments that could be made for circumstances that may not have been intended to be covered, but wind up doing that. What if the parent does request an evaluation and it's in the midst of a disciplinary situation? If a request for an evaluation is made during the time period where the child, gen ed child, is being subjected to disciplinary measures, the evaluation is to be conducted in a timely or even an expedited manner. Until the evaluation is completed, though, that gen ed student is going to remain in the placement that was determined by the school authorities, including any suspension or expulsion without educational services. What if a student's been dismissed from special education services? Well, assuming the student was properly dismissed in the first place, and that's another thing, but via reevaluation, IEP team, then technically the student is disciplined as a regular ed student. As long as we know we feel comfortable with that, but ultimately we have done it correctly, that the child clearly is not one with a disability. However, if we start seeing problems again, should be on our radar in terms of, did we make a good decision with respect to the reevaluation results and that dismissal that we decided on? The whole revocation of consent piece works into this one as well. We will not be deemed to have knowledge that a gen ed student is a student with a disability if the parent has not allowed us to conduct an evaluation or has refused services, initial services. Parents have the last say on that, obviously, because we need their consent to move forward with either. Or the student's been evaluated and is actually determined not to be a child with a disability. So parent refuses services, that child is treated as a non-disabled child for disciplinary purposes. I've had cases, though, where the parent comes back and says, well, you asked me to sign for an evaluation, so you know my child has a disability. That's not going to cut it. They can't have the cake and eat it too, so to speak. What about suspension days from last school year? I get this one a lot. Do they carry over? The 10-day count, so to speak, I put that in quotation marks, starts over again at the beginning of every school year. Okay, so if we want to call it recount, starts every school year. Here's another one, though. I don't think I have it in here. Let me see. No, I don't. What if a child moves from one Indiana school district to your district in the middle of the year, and they've already had 9 days of suspension, and they move to your, do you only have 1 day of suspension? So some people say yes. I tend to say no, not for purposes of discipline by that new school district. Now, if your state department, and I know state departments monitor it by year, and it's going to count as a monitoring issue. This child was out 15 days this year, doesn't matter what district they were in. But when you look at the language going back to rule number 2, where it says school districts can change the current placement for up to 10 school days, I think the current placement in the new district is the new current placement. So that's my story, and I'm sticking to it when I'm just doing an interpretation of the federal law. But I do know, and I've worked with some state departments on that, and we've agreed, yeah, for purposes of monitoring, it might count in terms of students with disabilities and how often they're suspended. But I view it a little bit differently under federal law, just to throw it out there, something to take a look at. How do we handle truancy issues? Lots of people will tell me that she's not a behavior problem, she's never here. Like, courts are actually more and more frequently saying, yeah, clearly, it is a behavior that significantly interferes with a child's ability to educationally perform well, so we may need to delve into it. It may be that we do that and we find that the problem is the parent's behavior problem. Maybe so, but we still have an obligation. Off-campus crimes, I just dealt with one of those yesterday when I got back from my presentations. A big question about a child who committed a felony over the weekend. And of course, in that state, the rule is that when the child returns to school, the child immediately enters into the alternative school program, cannot go back to the current program. I said, well, that's nice, that's under state law, but federal law says that's a change of placement. That's got to happen via an IEP team changing the student's placement in light of the circumstances. So that is going to be, I think, a problem to follow state law when federal law is supreme. Here are some other just miscellaneous questions. Can a student be placed in the sheriff's office to receive services? Well, that's the ticket. Let's just IEP them all to the sheriff's office. Maybe. There's a case in my materials from Mississippi where that's what they did, but they had a generous sheriff who dedicated some space to create some alternate to suspension classrooms. And a lot of my clients have actually done that with other agencies, come up with some potential placements for IEP teams to consider moving students to, rather than disciplining them, because many times we know they did was a manifestation, so we can't even go there anyway, so let's don't. I'm going to talk more about that in my dangerousness session. Can we require a student to be medicated? No, of course not. And I know that doesn't happen in Indiana, so you weren't worried about the fact that Congress changed the IDEA to say that we can never condition the receipt of services or an evaluation on a parent's agreement to medicate. And some of you might remember back in the late 80s and early 90s, I'm looking around going, just a few of you might remember this, when Ritalin was all the rage. And of course there are different alternatives now, but I remember ADD, known ADD, just plain old ADD, ADHD now, was also considered to be what many refer to as the yuppie syndrome. And there were numerous cases coming out where school systems were being dragged into litigation against the manufacturer of Ritalin, alongside psychiatrists and other physicians who were prescribing it like candy. And the interesting thing about it was there was an inordinate amount of this going on in the state of Utah. Well, I explored that a little bit and come to find out it was because Utah was where most of the Ritalin was actually produced. And they couldn't get it out of the state. People were buying it up before it was exported out of the state. So it was really interesting. But I'll never forget, I was walking around downtown Utah one time because I was there for a conference, and there was this fella there snapping some flyers, and he was handing these out. And he gave me one as I was just moseying along, and I looked down at it. And it was a pamphlet from the Church of Scientology. And it said, you know, I opened it up, and there was this big headline on one of the little articles, and it said, "Are you aware that schools are putting Ritalin into your child's school drinking water supplies?" And I looked down and went, good idea. Everyone would be better off drinking out of the water fountain, but it was all the rage. And so the Church of Scientology backed a lot of litigation, and some of the cases were against schools. And one of the cases I have there was a case where the parents actually wound up on Geraldo and Sally Jesse Raphael talking about schools doing just this. I was told by the principal that I had to medicate my child before my child could come to school. And so this was a huge, big issue. And so Congress responded to it later on. But the dairy case that I've listed in your materials was a situation where the IEP team actually wrote Ritalin into the student's IEP as a related service. Don't do that, okay? But so that's why they were on Geraldo. But we had a case out of Georgia, and Congress ultimately responded to that by putting in the IDEA that language that I have there in your materials. Can we discipline by denying participation in non-academic activities? So at the end of the school year, I got numerous calls about this. Well, right before the graduation, he brings a knife to school, or, so we're not going to let him walk. And the parents threatening to file for due process and all that. So is participation in the graduation ceremony part of the child's placement? Most courts that have looked at this have said no. It's not, in terms of part of the FAPE, that you're changing the placement by not allowing them to participate. So under IDEA, maybe not, but could there be a notion of discrimination there? Maybe in some cases, so it could be case-by-case scenario as well. So those are all of my practical tips and rules of discipline with 3 minutes to spare. So thank you so much for being here, this general session, and the entire conference. I thank you for everything you do, and I hope you have a wonderful school year. See you later.